by no doubt you've heard about the Fourth Amendment, but it doesn't guarantee protection from all searches and seizures. So Tom Sinus joining us now to explain when a vehicle can be searched and the exceptions. Now, I used to be a prosecutor, so this came into play back then, I guess.
Yeah, I was a criminal prosecutor for a number of years in Minneapolis, so I try to keep my ear tuned to when the United States Supreme Court issues important rulings dealing with the Fourth Amendment.
Yeah.
Why? Well, because the Fourth Amendment affects all of us, right? It's one of those amendments of the Constitution that even kids, I teach a course for ninth graders on constitutional law, and they know about the Fourth Amendment.
Sure.
What's the Fourth Amendment say? Well, it says that people have a right to be free from unreasonable searches and seizures. So over time, what the Supreme Court has said is that there are certain things that when law enforcement searches, law enforcement has to have a search warrant. On the other hand, there are certain things where the court has said you do not have to have a search warrant.
Because that was reasonable, essentially, is what they're saying.
Sure. So some people think you have to have a search warrant for any search, and that's actually not true. A classic example of an area where law enforcement do not need a search warrant is the automobile. Now remember, they still need probable cause in order to search an automobile, but they don't need to go down to court and secure a warrant from a judge. What about your home? Well, the home is one of these things that the United States Supreme Court has held very dear for centuries and centuries, and said, basically, if you, law enforcement, want to search someone's home, you got to have a search warrant. So why are we talking today? Well, because just a couple of weeks ago, the United States Supreme Court dealt with this case called Collins versus Virginia, where a guy is driving in his car, drives his car into his driveway, parks the car next to the driveway, and the police go up the driveway and search the car. And the defendant there says, you needed to have a search warrant.
Because my car's in my driveway, which is essentially my house, versus out on the roadway. That's very gray.
That's right. We call that area in constitutional law the curtilage to the house, right? There's the house and then the curtilage. And the curtilage is the driveway, the yard, the back patio.
Oh, boy.
The defendant says, my car is on my curtilage, which means you need to go get a search warrant if you want to search my car. The government said, it's a car. We don't need a search warrant to search a car. So you see these two areas of search warrant law intersecting. So what did the Supreme Court say? The Supreme Court said the defendant was right, that the car, once it became a part of the curtilage, the driveway of the house, law enforcement needed to go and get a search warrant. And really, the underpinning of the decision was the reason that you don't need search warrants for most searches of automobiles is because an automobile is typically one of these things that when it's pulled over on the side of the road, it's very easy for it to disappear. Well, in this particular case, the automobile was parked, and it was parked in an area that the Supreme Court has said for hundreds of years is near and dear to the heart and soul of privacy, which is your home.
Very interesting stuff.
We get some of these from time to time, and it's endlessly fascinating.
It is. It is fascinating. People have questions for the former prosecutor. Where do they find you?
Find me at www.sinusdramus.com. You can give us a phone call in West Michigan at 616-301-3333, or email us at info@sinusdramus.com.
Interesting stuff. Thanks, Tom.
Thanks, Derek.